Question 1. What is the maximum fee a New York Notary Public may charge for administering an oath or affirmation? A. $10. B. $5. C. $2. D. No fee is permitted for oaths. Answer: C. $2. New York law explicitly sets the maximum fee a notary public may charge for administering an oath or affirmation at $2. It is crucial for notaries to adhere to the statutory fee schedule and not overcharge for their services, as this is a common area of public complaint and potential misconduct. For example, if someone needs to swear an affidavit, the notary can only charge $2 for the oath. Always remember that charging more than the legally prescribed fee is a serious violation in New York. Question 2. A New York Notary Public's commission is valid for a term of how many years? A. 2 years. B. 3 years. C. 4 years. D. 5 years. Answer: C. 4 years. In New York, a notary public's commission is granted for a term of 4 years. This fixed term means that notaries must be aware of their commission's expiration date to ensure they apply for reappointment in a timely manner if they wish to continue providing notarial services. For instance, if you were commissioned on January 1, 2024, your commission would expire on January 1, 2028. Always keep track of your commission expiration date to avoid any lapse in your authority. Question 3. Under what circumstances may a New York Notary Public certify a copy of a document? A. Only if the original document is a public record. B. When explicitly authorized by statute, such as for depositions. C. For any document presented to them, provided they personally verify the original. D. New York notaries public are generally prohibited from certifying copies of documents. Answer: D. New York notaries public are generally prohibited from certifying copies of documents. A core principle in New York notary law is that notaries public generally lack the authority to certify copies of documents as true copies. Their primary role is to attest to the identity of a signer and the act of signing, or the administration of an oath. For example, a New York notary cannot certify a copy of a birth certificate or a diploma. Always remember that if a document requires a certified copy, it typically needs to be obtained from the issuing agency or a court clerk, not a notary. Question 4. Which of the following is considered an acceptable form of identification for a signer in New York? A. A well-known acquaintance who can vouch for the signer's identity. B. A foreign passport that is current and contains a photograph and signature. C. An expired driver's license, provided it expired less than 6 months ago. D. Any form of ID, as long as the notary is satisfied with the signer's identity. Answer: B. A foreign passport that is current and contains a photograph and signature. New York law permits a notary public to rely on a current foreign passport containing a photograph and signature as satisfactory evidence of a signer's identity. While the law does not explicitly list all acceptable forms of identification, it requires satisfactory evidence of identity, which means the notary must be convinced through reliable means. For example, if a signer presents a valid, unexpired foreign passport, the notary can proceed. Always ensure the identification is current, contains a photograph, and a signature to confidently identify the signer. Question 5. What action should a New York notary public take if a document presented for notarization contains blank spaces? A. Notarize the document as it is the signer's responsibility. B. Cross out the blank spaces before notarizing. C. Advise the signer to fill in all blank spaces before notarization can proceed. D. Fill in the blank spaces according to the signer's verbal instructions. Answer: C. Advise the signer to fill in all blank spaces before notarization can proceed. A notary public should never notarize a document that contains blank spaces, as this could facilitate fraud or unauthorized alterations after the notarization. The notary's duty is to ensure the document is complete and ready for execution at the time of notarization. For instance, if a loan document has unfilled sections, the notary must tell the signer to complete them first. Always insist that all relevant blank spaces are filled in before performing the notarial act to protect all parties involved. Question 6. A New York Notary Public is required to be a citizen or permanent resident of the United States. A. True. B. False. Answer: A. True. To be eligible for appointment as a notary public in New York, an applicant must be a citizen or permanent resident, lawful permanent resident, of the United States. This is a fundamental requirement for holding a public office and exercising the powers of a notary. For example, an individual holding only a temporary visa would not qualify. Always confirm that an applicant meets this citizenship or permanent residency requirement before they can become a notary. Question 7. What is the primary purpose of an acknowledgment in New York? A. To certify that a copy of a document is true and accurate. B. To verify that a document was signed by the person whose name is subscribed thereto, who appeared before the notary and affirmed it was their free act. C. To confirm the contents of a document are truthful under penalty of perjury. D. To prove the identity of a document's preparer. Answer: B. To verify that a document was signed by the person whose name is subscribed thereto, who appeared before the notary and affirmed it was their free act. An acknowledgment serves to officially certify that the signer personally appeared before the notary, was identified, and voluntarily signed the document for the purposes stated within it. It focuses on the authenticity of the signature and the signer's intent, not the truthfulness of the document's content. For instance, when signing a deed, an acknowledgment confirms the grantor willingly signed it. Always remember that the signer must personally appear before you and acknowledge their signature. Question 8. A New York Notary Public may perform a notarial act for their spouse. A. True, if the notary has no direct beneficial interest in the transaction. B. True, but only for an acknowledgment, not an oath. C. False, it is always prohibited to notarize for immediate family. D. False, unless the notary is also an attorney. Answer: A. True, if the notary has no direct beneficial interest in the transaction. In New York, a notary public is permitted to notarize documents for a spouse or other family members, provided the notary has no direct beneficial or financial interest in the transaction. The key ethical consideration is avoiding any situation where the notary could personally gain or lose from the transaction. For example, you could notarize your spouse's signature on a document if it's unrelated to your shared finances or property. Always ensure you have no direct beneficial interest when notarizing for family members to maintain impartiality. Question 9. Within how many days must a New York Notary Public notify the Secretary of State of a change of residence? A. 5 days. B. 10 days. C. 30 days. D. There is no specific time limit, but it is recommended to do so promptly. Answer: D. There is no specific time limit, but it is recommended to do so promptly. While New York law does not specify a precise time limit for a notary public to notify the Secretary of State of a change of residence, it is a professional best practice and strongly recommended to do so promptly. This ensures that the notary's official records are up to date and that important communications from the Department of State reach them. For instance, if you move, updating your address quickly helps avoid missing crucial notices about your commission. Always keep your contact information current with the Secretary of State's office. Question 10. A New York Notary Public's jurisdiction extends to A. The county in which they reside or were appointed. B. The entire state of New York. C. Only within their place of employment. D. Any state bordering New York. Answer: B. The entire state of New York. Once commissioned, a New York Notary Public has statewide jurisdiction and may perform notarial acts anywhere within the geographical boundaries of New York State. This means that a notary appointed in, for example, Erie County, can legally perform a notarization in New York City. The Commission grants authority throughout the entire state, not just a specific county or locality. Remember that your notarial authority covers all of New York, allowing you to serve clients across the state. Question 11. Which of the following acts is strictly prohibited for a New York Notary Public? A. Administering an oath to a person who is blind. B. Notarizing a document written in a foreign language. C. Drafting legal documents for a fee. D. Performing a notarial act for a relative. Answer: C. Drafting legal documents for a fee. A notary public is expressly prohibited from practicing law, which includes drafting legal documents, giving legal advice, or otherwise acting as an attorney for a fee. This is to prevent the unauthorized practice of law, which can lead to serious legal consequences for both the notary and the public. For example, a notary cannot prepare a will or a contract for a client. Always remember that your role is strictly limited to notarial acts, not legal counsel. Question 12. What is a jurat primarily used for in New York? A. To verify the authenticity of a court order. B. To certify that a document was signed under oath or affirmation. C. To acknowledge a person's signature on a deed. D. To record the date and time a document was filed. Answer: B. To certify that a document was signed under oath or affirmation. A jurat is the specific notarial certificate used when a signer takes an oath or affirmation regarding the truthfulness of the contents of a document, typically an affidavit, and then signs it in the notary's presence. It indicates that the signer personally appeared, was identified, took an oath, and signed the document. For instance, when someone swears to a statement in an affidavit, the notary completes a jurat. Always use a jurat when the signer is swearing to the truth of the document's contents. Question 13. Is a New York Notary Public required by law to maintain a journal or record book of all notarial acts performed? A. Yes, it is mandatory to maintain a journal for 10 years. B. Yes, but only for certain types of documents like real estate transactions. C. No, but it is highly recommended as a best practice. D. Only if they charge a fee for their services. Answer: C. No, but it is highly recommended as a best practice. New York law does not statutorily require notaries public to maintain a journal or record book of their notarial acts. However, keeping a detailed journal is considered a strong best practice as it provides a valuable record of services performed, which can protect the notary in case of questions or disputes. For example, documenting the date, type of act, and signer's identification can be invaluable if a notarization is later challenged. While not legally mandated, always consider keeping a journal for your own protection and professional accountability. Question 14. If a New York Notary Public changes their name, they must: A. Apply for a new commission under their new name. B. Notify the Department of State and continue using their old name until reappointment. C. Continue using their old name until the current commission expires, then apply with the new name. D. Notify the Department of State and apply for an amended commission with their new name. Answer: D. Notify the Department of State and apply for an amended commission with their new name. If a notary public changes their name, they are required to notify the Department of State and apply for an amended commission reflecting their new legal name. It is essential for the notary's official records to match their legal identity, and failing to update this information can lead to discrepancies. For instance, if you get married and change your last name, you must inform the state to ensure your notarial acts remain valid. Always keep your official name current with the Department of State. Question 15. A New York Notary Public receives a document where the signer is unable to sign due to a physical disability. What is the appropriate action? A. The notary may sign on behalf of the disabled individual. B. The disabled individual may make a mark, e.g., an X, which must be witnessed. C. the notary should refuse to notarize, as the signer must provide a full signature. D. The notary may allow another person to sign for the disabled individual without witnessing. Answer. B. The disabled individual may make a mark, e.g., an X, which must be witnessed. In New York, if a signer is physically unable to sign their full name, they may make a mark, such as an X, as their signature, provided it is done in the presence of two witnesses who also sign the document. The notary must then identify the person making the mark and perform the notarial act as usual. For example, if a signer has a hand injury, they can make their mark, and the witnesses will attest to it. Remember that while a mark is acceptable, it requires specific witnessing procedures to be valid. Question 16. What must a New York Notary Public do if a signer does not speak English and the document is in English? A. Refuse to notarize the document. B. Translate the document verbally for the signer. C. Require the signer to provide their own interpreter. D. Proceed with the notarization if the signer appears to understand, without providing interpretation. Answer. D. Proceed with the notarization if the signer appears to understand, without providing interpretation. A New York Notary Public is not permitted to act as an interpreter, nor are they required to ensure the signer understands the language of the document. The notary's duty is to identify the signer and attest to the act of signing, not the content's comprehension. For example, if a Spanish-speaking person brings an English document, the notary can proceed if the signer indicates they understand, but the notary cannot translate. Always remember your role is to notarize the signature, not to ensure language comprehension. Question 17. A person convicted of a felony in New York is generally disqualified from becoming a notary public. A. True. B. False. Answer. A. True. In New York, generally, an individual who has been convicted of a felony is disqualified from being appointed as a notary public. There are specific provisions regarding certain offenses and potential waivers, but the general rule is a disqualification. This requirement helps ensure that individuals holding public office maintain a high level of integrity and trustworthiness. For example, a person with a conviction for grand larceny would typically be ineligible. Always be aware that a felony conviction usually prevents a person from serving as a notary. Question 18. When administering an oath, what phrase is typically used by a New York Notary Public to swear in the deponent? A. Do you solemnly swear that the statements made herein are true to the best of your knowledge? B. Do you affirm under penalty of perjury that this is your signature? C. Do you swear or affirm that the contents of this document are true? D. Do you solemnly swear, or affirm, that the testimony you are about to give, or the statements contained in this affidavit, are true? Answer. D. Do you solemnly swear, or affirm, that the testimony you are about to give, or the statements contained in this affidavit, are true? When administering an oath or affirmation, a New York Notary Public should use a clear and direct phrase that elicits an affirmative response from the deponent, confirming the truthfulness of the statements. The inclusion of, or affirm, allows for individuals who object to swearing on religious grounds to affirm instead. For instance, when a witness is taking an oath before testifying, the notary would use this kind of language. Always ensure the deponent clearly responds, "I do," or "I affirm," to validate the oath. Question 19. What is the fundamental requirement for a notarial act to be performed by a New York Notary Public? A. The document must be executed in the notary's office. B. The signer must personally appear before the notary. C. The notary must have personal knowledge of the signer's identity. D. The document must be filed with the county clerk immediately after notarization. Answer. B. The signer must personally appear before the notary. The most fundamental requirement for any notarial act in New York is the personal appearance of the signer before the notary public. This allows the notary to verify the signer's identity and witness the act of signing, or hear the acknowledgment of a signature, ensuring the integrity of the notarial process. For example, you cannot notarize a document that was signed and mailed to you. Always remember that physical presence is non-negotiable for a valid notarization. Question 20. If a document requires a signature to be acknowledged, what is the core concept being affirmed by the signer to the notary? A. That the contents of the document are factually correct. B. That the signer personally signed the document and did so voluntarily. C. That the signer fully understands the legal implications of the document. D. That the document was prepared by the signer themselves. Answer: B. That the signer personally signed the document and did so voluntarily. When a document requires an acknowledgment, the core concept affirmed by the signer to the notary is that they are the person named in the document, that they personally signed it, and that they did so freely and for the purposes stated therein. The notary is not attesting to the truthfulness of the document's content or the signer's understanding of its legal effects. For instance, in an acknowledgment on a mortgage, the borrower confirms they signed it willingly. Your role is to confirm the signature and the signer's voluntary act. Question 21. A New York Notary Public is prohibited from performing a notarial act for a document in which they have a direct beneficial interest. A. True. B. False. Answer: A. True. A fundamental ethical and legal principle in New York notary law is that a notary public cannot perform a notarial act for any document in which they have a direct beneficial interest. This prohibition is designed to prevent conflicts of interest and maintain the impartiality and integrity of the notarial act. For example, you cannot notarize a deed for a property you are personally buying or selling. Always avoid notarizing any document where you stand to directly gain or lose financially or personally. Question 22. What is the maximum fee a New York notary public may charge for taking an acknowledgment? A. $10. B. $5. C. $2. D. 75 cents. Answer: C. $2. New York law stipulates that the maximum fee a notary public can charge for taking an acknowledgment is $2. This fee is standard for both administering an oath and taking an acknowledgment. For example, if a client needs a document like a power of attorney acknowledged, the notary's fee for that specific act is limited to $2. Always adhere to the statutory fee schedule to ensure compliance and avoid charges of misconduct. Question 23. A New York notary public may decline to perform a notarial act if they have reasonable doubts about the signer's identity. A. True, but only if they obtain legal counsel first. B. True, a notary has the right to refuse service if not satisfied with identity. C. False, a notary must perform the act if a proper document is presented. D. False, unless the signer is visibly intoxicated. Answer: B. True, a notary has the right to refuse service if not satisfied with identity. A notary public has the right, and indeed the duty, to refuse to perform a notarial act if they are not satisfied with the signer's identity or if they suspect fraud or coercion. The notary's primary responsibility is to prevent fraud, and if there are reasonable doubts, declining service is appropriate. For instance, if the photo on an ID doesn't clearly match the signer, you should refuse. Always remember you are the gatekeeper against fraud, and your professional judgment regarding identity is paramount. Question 24. Which of the following may a New York notary public legally refer to themselves as? A. Attorney at law. B. Legal consultant. C. Notary agent. D. Notary public. Answer: D. Notary public. A person commissioned in New York as a notary public should only refer to themselves by their official title, notary public. Using terms like attorney at law or legal consultant is a serious violation, as it falsely implies legal qualifications and constitutes the unauthorized practice of law. For example, when introducing yourself in a professional capacity, you should state, "I am a notary public." Always use your correct and authorized title to avoid misleading the public. Question 25. If a New York Notary Public's commission expires, and they accidentally perform a notarial act, what are the potential consequences? A. The act is valid but the notary will be fined. B. The act is invalid, and the notary may face misdemeanor charges. C. The act is valid as long as the notary reapplies within 30 days. D. There are no consequences, as it's a minor oversight. Answer: B. The act is invalid, and the notary may face misdemeanor charges. Performing a notarial act after one's commission has expired is a serious offense in New York. The act itself is invalid, as the individual no longer possesses the legal authority to perform it, and the former notary can be prosecuted for a misdemeanor. For instance, if your commission expired last month and you notarize a deed today, that notarization is void and you could face legal penalties. Always verify your commission status and never perform a notarial act if your commission has lapsed.